Ohio gives landlords broad freedom to set and raise rent, but the state has specific procedural requirements and a growing number of local initiatives that landlords need to be aware of. The governing law is found in the Ohio Landlord-Tenant Act, Ohio Revised Code, Chapter 5321, and while it doesn't cap rent amounts, it establishes the framework landlords must follow when making changes to the terms of a tenancy. Ohio does not have statewide rent control or rent stabilization. There is no state statute that limits how much a landlord can increase rent, restricts the frequency of increases, or requires government approval before a rent change takes effect. Ohio's political and regulatory environment has historically favored market-based pricing, and rent control legislation has not gained significant traction in the state legislature. Ohio has not enacted a specific preemption statute prohibiting local rent control, which is an important distinction from states like Texas or Tennessee that have explicitly barred municipalities from enacting rent caps. In Ohio, the question of whether municipalities have the authority to enact rent control under their home rule powers has not been definitively resolved. Ohio's constitution grants municipalities significant home rule authority, which means that a city could theoretically attempt to enact local rent regulations, though any such ordinance would likely face legal challenges. This matters because several Ohio cities have been actively discussing additional tenant protections. Columbus, Cleveland, Cincinnati, and Akron have all seen political activity around housing affordability, and tenant advocacy organizations in these cities have pushed for various forms of rent regulation. While no Ohio city has enacted traditional rent control to date, landlords in the state's larger cities should monitor local legislative activity. For month-to-month tenancies, the landlord must provide advance written notice before a rent increase takes effect. Ohio requires at least 30 days written notice before the next rental period for changes to the terms of a month-to-month tenancy. So if rent is due on the 1st, and you want the increase to take effect on May 1st, you need to deliver written notice by April 1st at the latest. The notice should be in writing and should clearly state the current rent, the new rent amount, and the effective date. Ohio doesn't prescribe a specific statutory form for rent increase notices, but the notice must be delivered by a proper method. Under Ohio law, notice can be served by personal delivery, by leaving a copy at the tenant's usual place of residence, or by sending by certified or regular mail. Using a method that creates a verifiable record is always recommended. For fixed-term leases, the rent is locked in for the duration of the lease term unless the lease includes a provision allowing mid-term increases. Common mid-term adjustment provisions include escalation clauses, provisions tied to property tax changes, and CPI-based formulas. Without such a provision, the landlord must wait until the lease expires to negotiate the new rent as part of a renewal or new lease. When a fixed-term lease is approaching expiration, the landlord should communicate the proposed new rent well in advance. Ohio doesn't prescribe a specific notice period for rent increases at the time of lease renewal. Because the increase is part of a new contractual agreement, but providing ample advance notice allows the tenant to evaluate the new terms and make an informed decision. If the tenant doesn't agree to the new rate, the lease expires at the end of its term. If the tenant stays and the landlord accepts rent, the tenancy converts to a month-to-month arrangement subject to the 30-day notice requirement. For week-to-week tenancies, the notice period for rent changes is 7 days, one rental period, before the end of the weekly term. Now let's cover the restrictions that apply even without a formal rent cap. Rent increases cannot be retaliatory. Ohio has a specific anti-retaliation provision under Section 5321.02 that prohibits landlords from taking adverse action, including raising rent, in retaliation for a tenant exercising their legal rights. Protected activities include making a good faith complaint about habitability to the landlord or an appropriate government agency, complaining about a code violation, joining or organizing a tenants organization, and exercising any right under the Ohio Landlord-Tenant Act. Ohio's anti-retaliation statute provides protections for tenants who engage in these activities, and a rent increase that is proximately caused by a tenant's protected activity can be challenged. Courts evaluate the timing of the increase relative to the tenant's complaint, the magnitude of the change, the landlord's treatment of similarly situated tenants, and any other evidence suggesting retaliatory intent. The consequences of a retaliatory rent increase can include liability for damages and attorney's fees, and the finding can undermine the landlord's position in any related legal proceedings. The safest approach is to document your business reasons for every increase, apply increases consistently across comparable units, and avoid any increase that could reasonably be perceived as punishment for a tenant exercising their rights. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and Ohio's own fair housing law, found in Ohio Revised Code Chapter 4112, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, disability, familial status, ancestry, or military status. Ohio's inclusion of ancestry and military status provides additional protections beyond the federal floor. The Ohio Civil Rights Commission investigates fair housing complaints and can take enforcement action, including ordering damages, injunctive relief, and civil penalties. Individual cities, including Columbus, Cleveland, and Cincinnati, have their own local fair housing ordinances that may provide additional protections. Columbus, for example, has enacted protections based on sexual orientation and gender identity that go beyond what state law requires. Landlords in these cities must comply with both state and local anti-discrimination requirements. A discriminatory rent increase can be established through direct evidence of intent or through circumstantial evidence showing a pattern of disparate treatment. Raising rent for tenants of one ethnicity while keeping rates stable for others in comparable units, implementing larger increases for families with children, increasing rent for a tenant after learning of a disability. Any of these patterns can support a discrimination complaint. From a practical standpoint, Ohio's rental market is diverse, with several distinct metropolitan areas and a wide range of market conditions across the state. Columbus has emerged as one of the strongest rental markets in the Midwest. The city has experienced significant population growth driven by technology, healthcare, education, including Ohio State University, financial services, and a diversifying economy. Columbus has consistently been ranked among the fastest-growing cities in the region, and rents have increased substantially. Landlords in Columbus generally have strong pricing power, particularly in desirable neighborhoods like Short North, German Village, Clintonville, and Grandview Heights. Columbus also has one of the more active tenant advocacy communities in Ohio, and the city has been at the forefront of discussions about additional tenant protections. Landlords in Columbus should stay informed about local legislative activity and be prepared for potential changes to the regulatory environment. Cleveland has a different market dynamic. The city has experienced population decline in many neighborhoods, resulting in a rental market with significant variation between strong and weak areas. Downtown Cleveland, University Circle, Tremont, and Ohio City have seen revitalization and rent growth, while other neighborhoods face high vacancy rates and limited pricing power. Cleveland's housing court is one of the most active in the state, and the city has enacted tenant protection measures, including a right to counsel program for eviction proceedings. Landlords in Cleveland should understand the local regulatory environment and adjust their pricing strategy to reflect neighborhood-level conditions. Cincinnati has experienced a renaissance in recent years, with significant investment in the urban core and surrounding neighborhoods. Over the Rhine, the Banks, and other downtown-adjacent areas have attracted substantial development and seen considerable rent growth. The University of Cincinnati drives demand in Clifton and surrounding neighborhoods. Cincinnati's rental market offers moderate pricing power, and landlords in revitalizing areas can implement meaningful increases. Akron, Dayton, Toledo, and Youngstown have softer rental markets overall, though each has pockets of strength. University-adjacent neighborhoods, downtown revitalization areas, and communities with strong employers tend to perform better than the broader market. Landlords in these cities need to be more strategic about rent increases, as the risk of vacancy is higher when tenants have more options. Ohio's college towns, including Athens, Kent, Bowling Green, and Oxford, have student-driven rental markets where demand follows the academic calendar and rent adjustments typically occur at the beginning of each lease cycle. These markets offer reliable demand, but also face competition from purpose-built student housing, which can limit pricing power for older properties. One best practice for Ohio landlords, given the varying regulatory environments across the state's cities, maintain awareness of local ordinances and court practices in every jurisdiction where you own property. Columbus, Cleveland, Cincinnati, and other cities may have different requirements for notice, disclosure, or tenant protections that affect how rent increases should be handled. A landlord who operates in multiple Ohio cities should have procedures tailored to each jurisdiction. Another best practice: time your rent increases to coincide with the annual property tax cycle. Ohio property taxes are typically assessed and billed on a known schedule, and many landlords use property tax increases as a transparent basis for rent adjustments. When you can point to a specific, documented cost increase, such as a property tax assessment, as the reason for a rent increase, tenants are more likely to understand and accept the change. For landlords with properties near military installations, including Wright-Patterson Air Force Base near Dayton and the NASA Glenn Research Center in Cleveland, BAH rate changes can affect the rental market. Military tenants' housing budgets are tied to their basic allowance for housing, and pricing should account for these rates to remain competitive for the military demographic. Ohio requires landlords to return the security deposit within 30 days of the tenant vacating and providing a forwarding address. While this doesn't directly regulate rent increases, landlords should understand that increasing rent doesn't automatically entitle them to collect additional deposit from an existing tenant. Any change to the deposit amount would need to be negotiated as part of a new agreement. For Ohio landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local Metropolitan Housing Authority. The authority evaluates whether the proposed rent is reasonable by comparing it to comparable unassisted units. Submit increase requests well in advance to allow time for the review process. For the complete guide to Ohio, rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.